Hi, I'm Toby Milrod, and I'm the incoming president of AAJ. I want to thank Council Financial, our diamond sponsor to the Amped Up Convention, and our exclusive legal funding sponsor. I've been working with Council Financial for many years, and I can say without reservation that were it not for the support of Council Financial when we were investing into some very big cases that needed some heavy support, we would not have been successful for our clients, for our case, for our law firm. Council Financial is there for you at every step of the way, and they're not afraid to roll up their sleeves and work with you to make sure that you have the funding that you need to help support your cases and your clients. They're a true partner in justice. So please not only thank Council Financial, but please get in touch with them and see if they can help you and your practice and your clients. Enjoy Amped Up. Thanks.
Hi, I'm Libby Vish, and I'm a Vice President of Business Development at Council Financial. I'd like to welcome Greg Coleman from Greg Coleman Law today to discuss the litigation in the European Union. Greg, thank you for joining us.
Well, thank you, Libby, and it's my pleasure and privilege to be here to talk about this issue.
So Greg Coleman is the founder and managing partner of Greg Coleman Law. 30 years of trial and appellate experience. He was named the 2016 and 2018 Knoxville Lawyer of the Year for product liability litigation. He has also been named by the U.S. News and World Report as one of the best lawyers and law firms in the country. So to start, give us an overview of mass tort litigation in Europe and how it differs from the U.S.
Yeah, thank you, Libby. Great question. There are a lot of similarities in terms of how it works, but the differences are with respect to you've got a well-developed area of law in the U.S. versus more of what I would call an emerging area in the EU and Europe, including the UK. So just like in the US, you aggregate or collect clients for mass tort cases. And then you have to deal with, all right, are we going to do it in the UK? Are we going to go over into the EU and those member states? Because you have to know the law of those member states if you're going to be there. And the way that we've done that with my firm, Whitfield Bryson and others, Phillips Grossman and others that I've worked with, we establish strategic relationships and partnerships with lawyers in the UK, in Amsterdam, for example, in Paris, Portugal, Brussels, you name it. And as a result of that, we are currently and have been and will continue to bring mass tort litigation into Europe.
That's wonderful. So how does mass tort litigation in the EU differ from in the US?
Specifically, if you were going to aggregate or do a mass tort in Europe, you look at the jurisdiction. Let's say we file it in the UK, and let me give you a real world example. We know that in the US, the Volkswagen emissions cheat device cases that is still ongoing in some respect, but the primary litigation was handled as a class action. There were some mass components, but the primary vehicle, pun intended, that was handled was as a class action, resulting in billions in dollars of settlements to the injured consumers, etc. Now, take that same case and do it in the EU or in the UK, for example, in London, where an action was brought, you sign up clients in the UK just as if you would in the US for a mass tort. Now, you can bring a class case in the UK, but I won't bore everybody with those details. You sign up the clients, you aggregate them as you would in the US, and then you can or possibly cannot, depending on what you choose, request what's called a general litigation order, and you proceed with the court's imprimatur, both agreement and structure, that's very different from what we would do in the U.S. So the primary difference is the jurisdiction. You sign up all your plaintiffs like you would in the U.S. You, of course, have to have competent and registered, barred, in a good way, counsel in London, and then you go about getting those clients signed up and proceed from there. It's just you have to dot a lot of I's and cross a lot of T's to be able to do it.
Wow, sounds like there is a lot to navigate.
Well, you don't roll out of bed and say to yourself, today I'm going to file a mass tort case in Europe. I was in Europe before the pandemic 9 times in 14 months. And so you have to, just like you would in the US, you have to learn and understand the law. Another big difference, Libby, cultural. They do not approach things like us Yanks or Americans would in terms of advertising, nowhere near the same that would be allowed in the US. Remember, in Europe, you have the GDPR, which is a relatively new data and privacy body of law that only allows certain things to occur, and it's a heightened sense of security. Well, we don't have anything exactly like that in the US. So you have to work and get your clients within the confines of the GDPR, the cultural differences, how they view advertising. You've got to have back-end office support available. And those are some of the differences, yet similarities to the US as well.
So I think that segues nicely into my next question is, what would you describe as the biggest challenge in taking on international cases?
Well, you can list knowing the law. That's
right.
Obviously one. Mm-hmm. You can list it's going to cost, because here is a difference, and a striking difference, to sort of go back to your first question. In the US, we don't have a loser pays rule. Well, guess what? When you go into the UK specifically, there's not as much emphasis on that in the EU, but I had to learn, and our group had to learn, okay, if you file a case, whether it's a class type case or whether it's a mass type case, depending on whether you file for that general litigation order that we talked about earlier, you've got to have the ability to pay if you lose. Well, just think about that. That can open up a large pot of liability that could rise up to bite you if your case doesn't work out. In the UK and in Europe, they have what's called ATE, or after the event insurance, that you in essence take out an insurance policy to cover any projected losses if you were to lose. Okay. And let me tell you, those premiums, they're not for the faint of heart. And so that's another striking difference. So we could say, number one, the biggest challenge is it could be the law. Mm-hmm. Number two, it could be the loser pays. But number three, the cultural differences. And then number four, the privacy, different sort of privacy concerns, security concerns. And any one of those at any particular time could be the biggest hurdle.
So much to consider over there. What are some of the prominent litigations in the EU?
Great question. It's funny to think that, again, talking about the emissions cases, in the US, we know that VW has, for all intents and purposes, been resolved. But in Europe, the VW emissions case is still ongoing. So that is a very prominent piece of litigation because it's established a lot of new law. And in fact, the ruling on the emissions case in the UK came out just a couple of months ago in April, finding for the plaintiffs against VW. Likewise, there was a Germany Supreme Court, of all things, being in VW's backyard, that just a few weeks ago, again found in favor of the consumer against VW and helped further outline what the damages, they call it quantum in Europe, but further helped us understand what the damages would be for those types of cases. So you've got prominent emissions case litigation in the EU. You've got emerging and prominent data breach cases in the EU and UK and the whole of Europe. And I specifically reference a Google decision that came out of the UK appellate court a few months ago that opened up, if you will, data breach and privacy causes of action in the UK. Okay. So those are very high profile. And then you have securities, antitrust, and those sorts of things.
So overall, what are the status of those litigations?
Well, with the decision that came out in the UK for the VW emissions case, that decision that came out 2 months ago, we know that there will be a damages portion of the trial that will occur early sometime next year. Now, between then and now, it may be ripe for resolution. Who knows? No one knows yet. But that case is further along than possibly some others in terms of potential resolution. For example, my firm, along with, I mentioned earlier, Whitfield Bryson, Levin Papantonio, Phillips Grossman, filed a companion VW case in the European Union in the Netherlands using what's called a stichting. No, I'm not saying a four-letter word. It's a legal vehicle that you bring these cases under, and we're representing hundreds of thousands into the millions of Netherlands car owners and in the European Union. So that case, depending on how things shake out, may also be further along in terms of status for resolution. We don't know yet. I'm not making any promises. I'm just saying that it's been done and we're involved heavily. Then you've got, with respect to the data privacy cases, data breach and privacy cases, the Google case that I mentioned earlier, where the great opinion came out from the UK appellate court. It's now in the High Court, and we should have an opinion on that case sometime within the next several months. So it's very akin to what we see in the US in terms of the time frame. It's just Europe is now opening up and is having all of these developing and emerging decisions that in large part, we hope and pray, are going to mimic the good work that's been done in the US.
Right. I realize asking that question and not hinting towards settlement, though, is always that magic 8 ball of.
Oh boy, look, I can only talk about what I can talk about. Having said that, that's not meant to indicate there's anything other than cases ongoing. Yeah.
I know. Yeah. I think I'll understand that.
Yeah.
So should law firms be looking to acquire international mass tort cases?
In my opinion, yes. And as I said, with one condition, that they use me, right? But just kidding. There's so much energy and synergy. I hate to use those words, but they're true. With respect to cases in the US that are translatable into Europe. And we're talking about consumer cases. We're talking about data and privacy breach cases. We're talking about securities and antitrust cases. And you name it. The difference is the body of law isn't as developed. There is overlap between the US. There's not exact overlap, don't misunderstand me. But there is some overlap between the consumer protection claims you can make in Europe, depending on where you are. You've got to know your venue and jurisdiction. There are breach of warranty claims. There are breach of contract claims. There are other related claims that we would routinely bring. There are securities and antitrust claims. So the answer is yes, there are mass tort cases. There are environmental cases, for example. There are many of those cases that would be transferable from the U.S. into Europe, as long as you know what you need to know when you file.
And it sounds like you know what you need to know when you
Well,
file.
as I say, if you'd asked me 3 years ago what I knew about the law in Europe, I would have said negative. But after 3 years and then being over there in the last 3 years, more than 10 times, that knowledge base has increased. Don't know everything, but for the cases that we're involved in, for sure. And when I say we, and I want to mention that because it's important, and we can talk about it. My firm, Greg Coleman Law, Whitfield Bryson, Levin Papantonio, Phillips Grossman, doing things both in the UK and in the EU, because there are those translatable and transferable cases.
So this question might test your knowledge base that you've accumulated over the last 3
boy.
years.
I've set myself up for failure, Libby. Yeah.
It's like, this is not as big as the bar exam, though. It's a little. What are your thoughts on the new rulings in the EU on consumer class actions?
Yeah, it's all thumbs up. All
Good.
right. It's both for the class and the mass world. With respect to the case that I've referenced previously, the UK ruling on the emissions, VW emissions case. I mean, I'm just quoting the ruling. This is not me trying to paraphrase. The court found that there was an abusive process in its ruling against VW, found that the conduct was deceitful. And so those types of claims are going to fly everywhere. That's a great ruling. Then you have the case that just came out a few days ago involving the Visa MasterCard decision that had been in the UK, or in the related appellate courts rather, in Europe. And they essentially found that those claims with respect to that antitrust question were viable. And so again, that's an overlap. Then you have the Germany Supreme Court ruling finding that VW violated its laws with respect to consumer protection, breach of contract, and those sorts of things. So there have been some significant rulings in the consumer protection area and antitrust, and the Google case that I mentioned earlier in the data and privacy breach cases that outline pretty clearly that the doors to the courthouse are opening in Europe, and that's always a great thing for the consumers and the public to see.
Absolutely. Okay, my last question today is one of those questions that we can't not ask in this time. How has the impact of the COVID-19 pandemic on litigation been different in Europe compared to the US?
Well, it's kind of been hand in hand, to be quite honest, Libby. There were slowdowns and shutdowns in Europe, just like we've seen in the US. We see now that Europe is opening back up, although maybe not to the US, right? That's for another day. But here's the great thing that all of us have learned during the pandemic. And no, I'm not trying to suggest you do anything other than participate via Zoom, WebEx. I'm not selling stock. I'm just saying we've all figured out how to creatively do workarounds, because that's what lawyers do, right? If we see a stumbling block, well, let's make it a stepping stone. And so what we've noticed, because I was literally, before I got on this call, as I told you off camera, I was literally on a call with the lawyers that I work with in the UK, and we were discussing next steps on various cases. That's how we get around it. We can use Zoom or WebEx or GoToMeeting or Google. And courts over there, although maybe not the exact same amount of technology, we've seen everything sort of open up to new ideas and new ways of doing things in light of a global pandemic.
Greg, thank you so much for taking the time to chat with us today. This has been really interesting. I could actually keep talking about it, but I know we need to be mindful of the time for AAJ. So again, thank you so much for your time today.
Hey, thank you so much, Libby. Appreciate it.
Hi, I'm Matt Rimmer, and I'm Vice President of Business Development and Attorney Relations at Counsel Financial. I'd like to welcome Erin Copeland from Fibich, Libby, Copeland, and Briggs today to discuss the Essure litigation. Erin, thanks so much for joining us.
Absolutely. I know that name is a mouthful, so thank you. You got it right.
Erin is a partner at her firm in Houston, Texas, where she primarily focuses on injury claims against medical device and pharmaceutical companies. Erin currently serves on the executive committee for the Essure consolidated litigations pending in California. And Erin also serves on the plaintiff steering committee for various pelvic mesh MDLs and the Pradaxa litigation. To kick us off, Erin, would you give us a brief overview of the Essure litigation and your firm's involvement?
Sure. So again, my firm is based out of Houston, Texas. We began this litigation several years ago. It was actually on the tail end of an AAJ conference where our small working group got together and started talking about some ideas with regard to this litigation. We'll get into it further, but the litigation was had a dark cloud over it from the very beginning because it's a Class 3 medical device that we're suing on, which means we've got a lot of preemption issues. So our small working group that's comprised of all AAJ members got together and we really labored intensely strategizing legal research to try to figure out what would give these women the best option going forward. Because at the time we got involved, while it was still early, at the time that we got involved, these women had been injured and complaining about their injuries for years to no avail. The company wasn't giving them any attention. The FDA had kind of just started hearing them, and the FDA started looking at this at the same time. So at the same time as when our small working group was strategizing, and we'll talk more about where we went.
Absolutely. And I know this device causes some terrible effects. Can you speak a little bit to the injuries and the causation that are driving the litigation?
Yeah, this, for those of the viewers that don't know, this is a permanent sterilization device. It was one of its kind. It was intended to take away the requirement for a woman to undergo a surgical hysterectomy or any other surgical procedure, or even a man, quite frankly, for permanent sterilization. And what ends up happening was, while this was touted to be a simple in-office procedure that should take no more than 10 minutes, doesn't require general anesthesia, once the device is implanted, and it's implanted into both of the fallopian tubes, it looks similar to a pin coil. You get a pin coil in each fallopian tube, and it's supposed to remain there forever. No chemicals, it's just simply supposed to block the sperm from meeting the egg and resulting in a pregnancy. And what we ended up finding out, and what the women were complaining about, was the fact that these devices actually didn't prevent pregnancy. Moreover, and most importantly, for preemption purposes, it required a surgical removal to get it out, because oftentimes the device would migrate out of the fallopian tubes, perforating the tubes and other organs in the body. And sometimes women not only had to have the hysterectomy that they were trying to avoid to begin with, but surgery, sometimes multiple surgeries, just to find those coils located somewhere within the body. And if anybody has seen me speak on this before, they've seen some really gnarly pictures of little coils in the spine in the liver, certainly not the fallopian tubes. And that's kind of the injury part of this case.
Yeah, I've seen some interviews on some of your clients, and the things that they go through are unbelievable. So can you take us through the current procedural status of the case?
Yeah, sure. So we were on the eve of trial I think we were set to go, we had varying dates. We were set to go in February, and the judge on her own moved it back a little bit. And then if I'm not mistaken, COVID, my memory with COVID is shady, but if I'm not mistaken, the court moved it again. And then I think we were at the very beginning of March to start our trial, and this arose. So the judge intended for us to start trial at some point in the spring. And what we were going to do is we were going to go 2 trials back to back. First, a plaintiff's pick, then a defense pick, or vice versa. But we were going to start trial, then COVID came. And now we are still there. We have started virtual hearings with the court. So we've now had 2 status conferences since COVID began. The court is talking about the idea of us having a fall trial, but our case is pending in Oakland, California. So Oakland courts and California in general has been very good about being mindful of COVID. So we don't really know exactly. We're anticipating a fall trial date, but that remains to be seen.
Gotcha. Can you tell us about the market status of the Essure product?
Yeah, fortunately for the women and women who may have considered this device, it got pulled from the market voluntarily by Bayer in July. They announced it in July of 2018, and the last sales were December of 2018. So starting January 1st of 2019, the product has no longer been on the market. And doctors, hospitals, to the extent they were implanting any, and other implant facilities were required to return any devices that they still had on their shelves. So as of today, the product is no longer on the market.
Well, if there's any good news, that's certainly it.
Yeah.
So I know you spoke a little bit about preemption earlier. Can you speak a little more on that, and then any of the other major challenges that you faced in the Essure litigation?
Yeah, this has turned out to be a pretty unique litigation, not easy to say the least. And then it's brought to light a lot of other issues that I'll mention. But let's talk with preemption, because that's what you asked. Because it is a Class 3 medical device, meaning it was approved by the FDA, not cleared. For those people that were involved in TVM, TVM was cleared by the FDA, which didn't incorporate preemption issues into the litigation, whereas Essure was approved. So that means it's gone through the most stringent review process with the FDA and ultimately got approval. The device itself, a little history, the device itself was designed, manufactured, and marketed by a California company called Conceptus. It was the only device that Conceptus had. And then ultimately Bayer took over Conceptus in 2013. Preemption was very difficult for us, but we surpassed it on the first level back in 2016 with our pleadings. Bayer challenged us and we defeated that. And the best way to describe this litigation and how preemption comes into play is to understand that this litigation is not your typical medical device litigation. While you've got claims like labeling or defective design, any claims that might exist pre-market are gone. They are preempted. So our claims in Essure can only be those that arose post-market. And the state of the law in California, the Ninth Circuit, was such that you could bypass preemption, for lack of a better phrase, if you were able to prove that the company failed to report reportable events to the FDA. And that's really the basis of our claim, and that's how we got past preemption. Our litigation is solely based on the concept that Bayer and its predecessor Conceptus had reportable complaints come into the company that they failed to transfer over to the FDA. And that's the crux of it. And that is how we got around preemption. Some of the other unique aspects of this case that may be a sign of the times, but it's certainly a big deal with Essure, is the social media aspect. Women, because they weren't getting any answers from the company, this product has been on the market since 2002. The company, as the evidence has shown, the company has been getting complaints beginning in 2003 on. And the more market share the company had, the more complaints that they were receiving. And we've joked in the past, but it's really not an exaggeration, that the company was receiving complaints and basically just shoving them in a drawer and not reporting them to the FDA like they were supposed to. So out of sheer frustration with not getting answers, the women, and oftentimes their healthcare providers too, were going straight to the FDA and saying, we need help. The company is not doing anything to help us. And that ultimately led to a bunch of things, but women banding together on social media, creating Essure Facebook pages, conveying and transferring information, talking about their injuries. And then ultimately that led to, along with Bayer taking over the company and trying to catch up complaints that its predecessor hadn't reported, all of those things culminated in the FDA convening an advisory committee meeting in September of 2015, where testimony was given. And that ultimately led to first a black box, then a restriction on the sale, and then ultimately the voluntary withdrawal of the product from the market. But social media is a big aspect that kind of, we knew about it, but we didn't realize it would play such an important role in this litigation. And I will say it's an important role. It's important even to Bayer, because Bayer, our deposition revealed, Bayer had a mole that was operating on the Facebook page. So while women were freely discussing their private health care and their complaints and ostensibly sharing their knowledge about what they believe their problems to be caused by, Bayer was tracking that. And that has come full circle in our litigation, because Bayer has successfully gotten cases dismissed, sometimes sanctions against attorneys for not properly completing fact sheets where social media information was requested. So they've had an opportunity in this litigation to be a little bit more aggressive where social media production has been involved. So that's kind of been a big deal for us here. And lastly, in terms of hurdles, statute of limitations, because like I said, the product has been on the market since 2002. So some of these women have been complaining very, very early on. A lot of them believed that their problems were related to Essure, and that's just a killer for women's claims in terms of statute of limitations.
You said it goes back all the way to 2015 litigation, or was it even earlier?
What we had is we had some random cases popping up around the country in 2015. Our litigation started, I want to say, in the spring of 2015 or 2016. And that was, again, the result of our working group really trying to strategize and figure out that California was the best place for this litigation, because what's happened is you've had litigations pop up elsewhere, with the exception of Marcus and Justin's, which is in the EDPA. Other one-off cases have tried to pop up around the country, and they've been getting dismissed based on preemption. We actually just got word that last week, a New York filing involving 3 women got dismissed based on preemption.
That's amazing. That really speaks to the grassroots power of social media and just the women banding together. That's great.
Yeah.
So since it dates back so far, I wanted to ask, should attorneys be looking to sign up new cases at this point?
My personal opinion on that is no. I think it's late. I think Bayer is absolutely in tune with the concept of people advertising and acquiring cases this late. But let's just take what Bayer thinks out of the mix. The reality of it is the black box got put on this product in October of 2016. The FDA advisory committee that ultimately resulted in the black box was in September of 2015. So we're talking knowledge could arguably be put very, very early on. So a woman needs to be very conscientious about her claims. And even if there is a lawyer who gets a case in, there might be some relief for women who had the removals more recent than early on. Those people might have a colorable claim, but any attorney who gets a new case like this is going to want to look at statute of limitations for their woman's state of implant. They're going to want to look at learned intermediary law, but most importantly, they're going to want to make sure that these types of claims are available to that woman in her state. Because even though we have a California JCCP, our judge is blending her choice of law decisions. So California law applies on some issues. The state of residence or state of implant applies on others. And with regard to the preemption and the failure to report complaints to the FDA, that is going to be a state-specific issue. I can tell you as an example, Arizona State Supreme Court, while our JCCP has been pending, came out with a decision that said they do not recognize these types of claims. So women in Arizona should really, really, really consider whether or not they have a claim. Lawyers should really think twice about signing up women in Arizona. It's unfortunate, but that's just the state of the law.
We mentioned COVID a little bit earlier. Were there any other COVID-related setbacks that come to mind?
No, we had some concerns in the very beginning, but at the end of the day, no. The only thing that COVID has done has prevented us from actually having in-person hearings. We had about a month and a half where the court system was trying to get its bearings on how to do virtual hearings and status conference. But like I said, we've done 2 now. The pace has picked up in terms of the litigation. For example, the court just recently issued an order activating about 800, let's just say several hundred cases for case-specific workup. In other words, plaintiff depositions, doctor depositions, and whatnot. And the court has approved virtual depositions. So people are not going to be able to come to her and argue COVID or anything like that prevents them from having their deposition taken, because we are living in a virtual world and the court has adopted it fully.
That's good. So it's getting back on track.
Yeah.
Well, Erin, thank you so much. Most importantly, thank you for advocating for these women. And if you have any closing remarks or any last minute thoughts for the AAJ members watching.
The closing remarks I would make is just, if you do have an Essure case come across your desk at this late date, look at it very, very thoughtfully and really consider whether or not it's something that you want to do. Remember, again, that it's been off the market now for a while. The black box was even earlier, and the AdCom hearing was even earlier than that. So you really got to look at statute of limitations for your woman's state, and you really got to look at learned intermediary and preemption issues, because those can be absolute barriers to any recovery for these women. I would also encourage people to explore your potential clients' social media usage, because again, Bayer has been monitoring it for years. So if your woman says no, she hasn't been on social media, or no, she's not aware of issues involving the Essure device until her doctor told her it was removed, that's going to need to be vetted very fully, because Bayer has knocked on people's doors saying, hey, this is not necessarily true. So I just caution anybody coming in at this date. And then last but not least, The court's recent order activating hundreds and hundreds of product and place cases, if that tells you anything, it tells you this. The court and the defendants, but again, no disrespect, but we don't really care what the defendants say. The court is very mindful of the defendant's argument that product and place cases are not real injury cases. So she wants to vet that out. So if you've got a product and place case, expect there to be no respect on the part of the defendants and possibly even the court with a case like that.
All right, that's some great advice about getting your due diligence done on these cases. Erin, thank you again for your time. We really appreciate it.
Thank you. Appreciate the ask. Thank you.
I'm Elizabeth DiNardo, and I'm Associate Counsel at Counsel Financial. I'd like to welcome with me today Amanda Klevorn from Burns Charest to discuss the Truvada TDF drug litigation. Amanda, thank you for joining us.
Thank you so much for having me.
Amanda has been with Burns Charest for over 4 years. She specializes in consumer-oriented complex litigation in both federal and state courts. Her clients range from homeowners, landowners, patients harmed by defective products and drugs, and victims of federal civil rights violation. Amanda, let's get started. Can you give us a brief overview of Truvada and your firm's involvement in the litigation?
Sure. So this litigation focuses on injuries caused by what I'll refer to as TDF-based drugs, manufactured specifically by the California pharmaceutical company Gilead. The T in TDF stands for tenofovir, so that's actually the active ingredient that is at issue. And one point I always like to make right off the bat is that sometimes folks refer to this as the Truvada litigation, and that makes sense because Truvada is probably the most well-known of Gilead's TDF drugs. But I'd just like to clarify for people that there are actually 4 other Gilead drugs containing TDF that are also at issue in this litigation. And so the drugs at issue are Viriad, Truvada, Atripla, Calcaterra, and Stribold. They're all manufactured by Gilead, they all contain TDF, and they're all prescribed to treat HIV. Truvada is the one Gilead TDF drug that can also be used by someone who wants to prevent contracting HIV. And so I think that's maybe why it's a little more well-known, but 5 drugs altogether at issue. And so I would say the central allegations at issue in the litigation are that Gilead, unbeknownst to the public, unbeknownst to the plaintiffs obviously, had actually developed a safer version of tenofovir back in the 1990s, right at the same time that TDF was developed. And I'm only going to say this once and then I'll abbreviate it, but the safer version is called tenofovir, hang on, I'm looking for it, alafenamide fumarate, so TAF rather than TDF, developed at the same time. TDF, however, is toxic to users' kidneys and bones, while TAF is far less toxic. And finally, Gilead knew at the time that TAF was safer, and yet brought TDF to market first. And so I don't want to go too far down the science rabbit hole, because that's definitely not my area of expertise. But the short answer as to why TDF is more dangerous than TAF is because you need a larger dose of TDF to target the bad cells that you're going after. And specifically, patients need approximately 12 times more TDF than TAF to achieve the same therapeutic effect. And so that means people taking TDF end up with abnormally high levels of tenofovir in their bloodstream, in their digestive system, ultimately in their kidneys, that the tenofovir builds up there, and that is what causes the kidney injuries. It also, the kidney's failure to function properly leads to mineral losses that precede bone loss. And so that's why those specific kinds of injuries are happening with TDF. Despite knowing that TDF was safer, as I said, Gilead brought TDF to market first and only introduced TAF as an alternative when Gilead's patent exclusivity on TDF was coming to an end. And so Gilead reaped huge profits over that 15-year period of time with TDF. Truvada alone, I think, was over $30 billion that Gilead made over a 10-year span. So as a result, hundreds of thousands of people living with HIV, as well as people who use Truvada prophylactically to prevent HIV, were exposed to a very toxic drug for a long time, and many now suffer kidney and or bone injuries as a result. The specific injuries, when we talk about kidney injuries, you'd be looking for chronic kidney disease, renal insufficiency, renal failure. Those would be the primary injuries. On the bone side, you're looking at loss of bone density, loss of bone mineral density, bone breaks, bone fractures, and bone necrosis. Also sometimes tooth loss, secondary to the loss of bone density. So that's sort of a general overview of the allegations and the injuries that we're focused on.
Great. Can we get into a little bit of a discussion about the litigation itself and the causation that's driving litigation?
Of course. Yeah. We're very early in the litigation, but it is moving at a pretty quick pace, even in the midst of a pandemic. We had a hearing on Gilead's demurrer just a few weeks ago. That's sort of the California motion to dismiss. And we hope to receive a favorable ruling this summer. Case-specific discovery is already underway. Plaintiffs generally have 30 days from the date their case is consolidated in the JCCP to submit a profile form. Unfortunately, the parties were able to negotiate a very reasonable profile form in this case. We've all dealt with the 25-plus page monster fact sheets in other cases, but it's actually very manageable in this case. The leadership committee is already reviewing and vetting cases for bellwether selection. Under the current case management order, the first bellwether trial is slated to begin in January of 2022. So we're all working hard, trying to hold that trial date and keep the litigation moving. But it's moving at a pretty quick pace, even despite the pandemic situation that we're all in.
So there hasn't been any real setbacks due to COVID that would slow down significantly the...
No, I would say no. We haven't had any major setbacks. We are dealing here with a group of clients who have underlying health conditions, who are in many cases more at risk during a pandemic situation. And so, that can create a lot of logistical problems for them. We have clients who don't feel safe going to the post office, right, to mail their profile form back to us. But I will say the parties have been working together in a fairly amicable way to deal with those issues as they come up. We've been able to negotiate extensions for profile forms. But in the big picture, no, I would say COVID has not upset the overall schedule. Maybe we'll need to make some adjustments depending on how the rest of the year goes and what happens with this pandemic. But for now, I would say the train is still very much on track, thankfully.
That's great. So have there been any previous trials or settlements involving this drug?
No, there have not. Again, it's so early. The JCCP was just created, I think, late summer of last year, 2019. So no trials, no settlement talks that I know of. It's early in the process, but the litigation is already huge. There are, I know, more than 10,000 cases on file. It could be closer to 15 or even 20,000 now. So it's pretty big, but still early. So yeah, no trials yet and no settlement talks.
And what's the market status of the drug right now?
TDF-based drugs are still all on the market. Unfortunately, they are out there. Interestingly, though, Gilead has now introduced its TAF-based drug. It's called Descovy. It came on the market in 2016 for the treatment of HIV. It was recently approved, like Truvada, to prevent HIV as well. So TAF is now out there. It's available for people, but unfortunately, TDF is still on the market as well.
So what do you say the major challenges involved in this litigation are?
Honestly, it's hard for me to really identify any major challenges with respects to the merits of the litigation. The science on TDF's toxicity to kidneys and bones is actually very strong. Finding proof of TDF use in people's pharmacy records is usually pretty straightforward. Same for finding evidence of bone and kidney injuries in the medical records. I would just say, again, sort of similar to what I said before, the real challenge, to the extent there is one, is really that we have sort of a fragile client base, people with underlying health issues. So I would say it's particularly important in this litigation to stay engaged with your clients, contact them on a regular basis to make sure they're okay. That issue has only been compounded by the COVID pandemic. And so, we've had clients we've had trouble contacting, and it turns out they were in the hospital for several weeks because they got sick. So client contact, keeping tabs on your client's well-being and whereabouts is probably especially important in this litigation, even more so than other cases I've been involved in.
Because you're dealing with an already immunocompromised group.
Exactly.
So what should attorneys involved in this litigation be looking for during case intake?
Yeah, I think it's actually pretty straightforward. You know, you're getting the pharmacy records and you're first off the bat wanting to see that the person took at least one of Gilead's TDF drugs. And then you want to look in the medical records and see if they developed a bone or kidney or both issue at some point after using the TDF drug. And on the question really of how much TDF use is enough, my firm is qualifying basically any use if they used it at all, because we've had greater scientific minds than mine for sure look at all the studies, and what they found is that the increased risk of developing those kidney and bone issues is present even after very little exposure to TDF.
Okay. So would you suggest that law firms start looking to acquire TDF drug cases?
I would absolutely encourage people to take a look at TDF. You know, we're still in the early stages of the litigation, so you haven't missed the boat on this. There are sadly probably thousands of cases still out there, and people receiving new kidney and bone disease diagnoses every day. So if it's something you're interested in, I would definitely look into it.
Great. Amanda, thank you so much for joining us and giving us this detailed recap of the TDF drug litigation.
My pleasure. Thank you so much for taking the time to talk to me.
I'm Elizabeth Donardo, and I'm Associate Counsel at Counsel Financial. With me today to discuss the Rock and Play litigation is Regina Calcaterra from Calcaterra Pollack. She specializes in complex federal and state litigation, in addition to being a New York Times bestselling author. Her co-founding partner, Janine Pollack, has been a class action litigator for almost 30 years. Jeannie is also the firm's Chief Wellness Officer and provides opportunities for the firm's personnel to enhance their well-being and improve their physical and emotional health. So let's get started. Can you first tell me when you began investigating the dangers of Mattel and Fisher-Price's Rock and Play sleeper?
It started in very early 2018. I have a friend of mine, Ryan Cronin, who works at Blank Rome, which is a defense firm. And Ryan's wife, Katie, is a pediatric healthcare provider, and she's also on the Columbia University Board of Nursing. And so she's very well aware of the dangers of certain sleep products because how they have caused death in the past. And so Katie's been telling Ryan for a while now that the Rock and Play should not be advertised as a sleeper because babies should not be sleeping in something that's inclined. Because when a baby sleeps on something that's inclined, and she described it to me, is when they fall asleep, and if the parents fall asleep while the baby's in it because it's advertised as a sleeper, if the infant is small enough and their head falls forward, they don't have the strength for their head to go back. So they end up suffering from positional asphyxiation. And sometimes because of the padding on the side of the Rock and Play, if a baby rolls over, they can't adjust themselves to roll back over and they end up suffocating. So she was really concerned that this product was on the market since 2009. So Ryan told me that, in her sharing her concerns with him, he thought that this could potentially be a class action case against Mattel and Fisher-Price because Fisher-Price is the developer of the Rock and Play. Mattel is their parent company. And to try to get them to change their advertising, to not say that it's a sleeper and not continue having pictures on their boxes of mothers that are falling asleep in a bed while their infant is in the sleeper on the ground, therefore implying that the mothers could sleep while the babies sleep and the baby doesn't need to be attended in this. So he had expressed his concerns and he understood that, I was with a class action firm and we've known each other for a while. So he said he wanted to talk to me further about it. So we started having conversations after that early January 2018 meeting, and he shared his research with me. And his research included the fact that Australia in 2010 banned the Rock and Play from being sold as a sleeper in Australia. It couldn't be sold at all because of its incline. Because for decades, Australia and many other countries, just like the US, had this program that they developed for safe sleeping because babies were dying of SIDS and they wanted to make sure that parents and caregivers knew that a baby shouldn't be on an incline. A baby should not be in a crib with blankets and bumpers and stuffed animals. the safest way for a baby to sleep is on a flat, firm mattress with nothing around them. And that has been a program that has been promoted here in the US and in other countries for decades. So all of a sudden, when Fisher-Price put out an inclined sleeper on the market with a 30-degree incline, it violated all of these guidelines that were put out by these safe sleeping organizations and the American Academy of Pediatrics. And that is why Australia said, you're not allowed to sell that as a sleeper here. And in fact, he also shared with me research that he found that Canada, in and around 2010, also said the same thing to Fisher-Price and Mattel and said, you can't sell it as a sleeper here. So what they did at that time is they took the word sleeper off and they just sold it as a product. So when you take the word sleeper off, it kind of denotes that you can't allow that child to sleep in there, and you can't be taking naps while the child sleeps in there. And not only that, he also found research about a wrongful death litigation that was in the Southwest. And he said, there is proof that babies suffer from asphyxiation on this. So he gave me all of this research. And then from early 2018 to early 2019, we did a tremendous amount of research to further try to kind of bring a complaint against Fisher-Price and Fisher-Price and Mattel for the rock and play. And one of the things that we found was that through this litigation, there were depositions that were taken. And there were depositions that were taken by people who worked at Fisher-Price, who came up with the idea of having an inclined sleeper and said that they heard that it would be helpful to reduce acid reflux for babies. And these depositions also showed that they never did any type of testing that it could cause positional asphyxiation or suffocation. They only did tip testing to see if it would tip over. And that they relied on a doctor who really didn't have any pediatric experience, who later got disbarred. And when we found this out, we dug a little bit more into those depositions, and we actually realized that one of the principal engineers who were in charge of making this product, his name is Michael Steinwachs, and in charge of integrity for the product, just came up with the idea of having a 30-degree incline, even though inclines were prevented in sleeping products. And he said he based it upon a car seat. That car seat's a 45-degree incline, so we'll just go with 30. And he literally said that in his deposition and admitted that there was no testing. So we realized, because not only the fact that it's being advertised as a sleeper, it has been banned in other countries, that there were damaging depositions that we found by those who were in leadership positions and were responsible for the safety of the design and the marketing of the design, that clearly it would show that they didn't do what they needed to do to make sure that they would safeguard infants. Then what we also found is what came up on the regulatory scheme in 2010, because Fisher-Price put this on the market in 2009. In 2010, a federal agency called the United States CPSC, the Consumer Product Safety Commission, came out with regulations, proposed rules, and actually said that they were going to ban inclined sleepers for infants that were more than 5 degrees. So they put out these proposed rules. And so we started taking a look at everyone who was submitting their concerns about these particular rules. There were groups like the AAP and other groups that support safe infant sleeping that were saying they should be banned. There should never be an incline in any type of sleeping product for a baby. But then we started taking a look at letters that were submitted by Fisher-Price. And Fisher-Price was basically saying that this was proof that, well, the whole goal of this was to put a product on the market that dealt with acid reflux. And they try to say over and over and over again in one particular person, that it cures acid reflux and there's no other products out there and this is necessary. And then they basically said in the letter also, by the way, CPSC, if you ban these products, there are over 10 companies that are going to go out of business. So basically they put in this letter, this is really about money and this is what's going to happen. So then we went back to look at the deposition of the signatory of that letter that was done in 2018, even though she wrote that letter around 2010, and she denied ever having any recollection that it was designed for acid reflux. So basically by kind of gathering all this information that was out there in all these disparate places, all through 2018 and early 2019, that led us to drafting a complaint and sending it to Mattel. Mattel is in LA County and Fisher-Price is in Buffalo. So we sent it to Mattel, who's in LA County, and we basically put them on notice and said, this is a very comprehensive complaint. We've got deposition testimony. We have your submissions to the CPSC. We have learned that infants have died. We understand that other countries have banned this, and but you're still selling it as a sleeper here. And we deplore you at this time to take it off the market, that we're going to bring this lawsuit. And like I said, this is late February 2018. We're going to bring this lawsuit to try to get you to change the advertising, just take sleeper off of it. And they asked us, after they received this, a few weeks later, they contacted us in late March 2019, and they said, can you just wait a few more weeks until you file this case? And we agreed. And what we didn't realize is what they were trying to do was plan their defensive, and or really their offensive. Because then what happened 2 weeks later is they actually joined with the CPSC, a federal agency that is supposed to ensure safety in products. They joined together and issued a press release on a Friday night on April 5th, 2019, and said that they put out a warning there that the Rock and Play sleeper has resulted in 10 babies dying in the Rock and Play since it's been put on the market since 2009. But basically, it's the parents' fault. The parents weren't following the rules. And when caregivers don't follow the rules, that's what led to their death. So basically what they were trying to do was get out in front of this and say that it's not their fault, it's the parents' fault, it's still a safe sleeper as long as you follow what the rules are. And or the rules that they put out, one of the rules is that the baby has to be strapped in. And but then a few days later, after they came out with this report that 10 babies died, Rachel Peachman, who is a fantastic investigative journalist with Consumer Reports, put out a story that basically said, you're wrong, CPSC and Mattel and Fisher-Price, you're wrong, because more than 30 babies died. And the reason why she knew that is because she inadvertently got data from the CPSC that was unredacted that identified that over 30 infants died, and it was in Mattel and Fisher-Price's incline sleeper product. So she was able to then respond to that and say, and it's not too, we're not too sure it's really the parents' fault, because by then she had already interviewed families who lost their infants in the Rock and Play. And after that, and 2 days later, Fisher-Price alone, not with the CPSC, they alone at this point, they did a recall of the incline sleep products. So there was a series of things that kind of led to the recall. One was our year-long research, where we actually provided them with this extraordinarily comprehensive complaint that you usually don't have until you have some discovery, but we were finding it, everywhere in public domains. And the second was they knew at the time that Consumer Reports was doing this study, because she kept going back that they were going to do this article, because she probably kept going back to them to ask questions about what her findings were. So they tried to get out ahead of it.
Wow. So it sounds like the information was all out there, but you guys were the first ones to start really digging into it.
Yes, absolutely. And globally and domestically.
Wow, that's amazing. So your work really triggered the recall, would you say?
It contributed to it. There were a variety of different factors. There was the great work that was done by investigative journalist Rachel Peachman from Consumer Reports, and she's continued to report on that, over the past year after the recall. And now she has recently reported that in March of this past year that over 90 babies have died. And so it was that, and then it was families whose infants had died that were trying to complain and trying to get the CPSC to kind of pay attention to it. So I think it was a series of three things that were going on at the same time, but not collectively. Like we weren't working with the families who lost their infants because we didn't know them yet, right? And then Rachel was doing her own investigative reporting. But the interesting thing when you think about what causes change, right? There has to be media attention. People have to be focusing on it. It has to be something that really just like it pulls at your heartstring. It forces you to kind of move. And then, of course, if that doesn't work, then a lawsuit. So the three of them all kind of collided at the same time.
So what happened as a result of the recall? Because sometimes when recalls happen, the consumers are just inundated with a ton of information and it's too much and they really don't absorb it. So is the Rock and Play sleeper still being used?
There's there's multiple parts to your question. So I'm going to share with you what happened immediately thereafter. the first thing that happened is, since we had drafted that, the class action complaint that we provided to Mattel, we then filed it. And then other, law firms across the U.S. kind of did the same thing. And as a result of these multiple class action suits, a multi-district litigation was formed in Buffalo, where Fisher-Price is. And my peers who worked with me on it at the time are leading that MDL. So we now have an MDL in a consumer class action that is forcing them to not only address the issue of advertising, even though it's no longer on the market, but also to reimburse those out there who actually purchased it or were gifted it. But more importantly, the most important aspect of this MDL and what the plaintiffs are seeking is an educational campaign, is to go back and stop blaming the parents and start saying it was the incline, and tell everyone about the dangers that could occur if you let your baby sleep in one of these products. So that is something that's kind of moving forward. Something else that came out of it is that we actually were contacted by many families across the US who lost their infants. And so myself and in cooperation with Ryan Cronin from Blank Rome, we've got a plaintiff's firm and a defense firm actually working together, suing Mattel and Fisher-Price, representing these 8 families. And there are other families out there who've also filed lawsuit as well. A third thing that happened, which we didn't really know what was happening at the time, is that the CPSC, which was the same agency that was lobbied by Fisher-Price. And by the way, when they were lobbied by Fisher-Price, what the CPSC did is they listened to Fisher-Price. When they proposed these rules, when they finalized the rules a few years later, around 2013, they made an exemption for inclined sleepers. So they not only made an exemption for inclined sleepers, they then said, well, instead of making mandatory regulations about inclined sleepers and preventing them from being sold, we're going to have a task force at the ASTM, which is an international kind of code group, come up with what they think would be good standards for inclined sleeping. And what happened is this inclined sleeping task force that was put together at the ASTM was chaired by Michael Steinwachs. Michael Steinwachs was the same guy who was the engineer who designed it, who also said he just made up that 30-degree incline, wasn't based on anything, and there was never any medical testing. Now he is sitting here chairing a committee trying to regulate inclined sleep products. And in 2015, when the sleep products came out, he basically said they don't need to be regulated, and he got an award for that. So the CPSC was, from our perspective and the plaintiff's perspective, they were complicit with Fisher-Price and Mattel by putting this item on the market and not making sure that it was properly tested. So what they did, and this has happened around the time of the recall, goes back to what your question is, they actually hired a scientist down at at Arkansas State University Medical Center to do testing. And she tested for months and months and months and infants, and did to determine whether or not an infant can die, based upon, their weight, their size, rolling over, and all these other factors, whether or not the rock and play sleeper causes positional asphyxiation or suffocation. And her study came out in September 2019, 5 months after the recall, and she said it did. And she showed proof by proof about how infants had died in the sleeper. So that was one of the amazing things that came out of it, is that the agency that seemed to be on the side of supportive of Mattel and Fisher-Price and having this on the market, all of a sudden seemed to do somewhat of a reversal by hiring someone to do this independent study. And then once the report came out, they're like, this is what it is, we're going to issue it. And something like that that definitely brought great comfort to our clients. And again, going back to your question about, what resulted as far as the recall, you not only had the MDL class action cases, you also had the wrongful death cases against Mattel and Fisher-Price. You had the CPSC issuing this very, very important, the results of the study, which proved that the parents did nothing wrong. And but then you also had a lot of parents speaking out. And that is something that our clients did, that they wanted to do, because there was shaming. When the CPSC came and Fisher-Price on April 5th came out with a statement basically saying that 10 babies died and it was the parents' fault, our parents started vocalizing, that their concern, and that maybe this is what happened and to their baby. And once they did that, they started being shamed by others, saying, well, I used a rock and play for 3 or 4 of my kids and nothing ever happened. You had to do something wrong. So they were literally being shamed and blamed for the death of their child. So once this study came out, it also provided them some level of comfort that they were right, that they didn't do anything wrong. It was the inclined sleeper that did it. And so what they started doing was just started speaking to the press. They were on, CBS this morning with Anna Warner, just on 2 national shows, trying to raise awareness about the dangers of the rock and play. They were featured in Rachel Peachman's Consumer Reports stories. And the reason why they were doing this is because they knew that rock and plays were still out there. Because like you said, there's so much press and so much noise out there. What is it that we pay attention to? And people don't necessarily pay attention to recalls. So there were families who still had a rock and play sleeper in their house. They were having their next child use it. There were friends who were giving it to their friends, or people were still asking for it as a gift. Even after the recall, it was still being sold in the clearance center of certain nationwide stores. We were having people send pictures of us of where it was still being sold. And most frighteningly, they were still being used in daycare centers.
I read that, yeah.
For some reason, daycare centers are not advised of every single recall out there about a prospective infant product or pre-K product. And that showed, because then there was a national survey of daycare centers of whether or not A, they were aware, and B, they still had a rock and play there. And the numbers that came back were pretty impactful. So that was another problem that we had realized, is that the word is just not getting out there. And so that, again, re-energized the families who lost infants to keep articulating, keep kind of sharing about what the dangers are of it. So that recall actually had a ripple effect, a series of things and impacts. Not only the families being their own advocates of and trying to protect other infants, but then there is the litigation, which is what unfortunately sometimes is what really kind of forces change. And then there's national media exposure.
And can you tell us a little bit about how the families that you represent are doing now, since they found a voice?
They finding their voice and speaking out about this doesn't heal what it was they experienced. And we have 8 families, and I will tell you, unfortunately, 3 of them had twins.
Awful.
3 different families had twins, and 3 of the families lost their twin. Lost 1 twin in each family. So we now have 3 twinless twins that are out there, and that will have a long-term effect on the infant sibling, the surviving infant sibling. And they are struggling. It's not something that they can move past. We have been to their homes. We've seen them. We spent time with them, we being Ryan and I. We see how they honor their children, how they have memorials in their homes for them, how they honor them for their birthdays or around the holidays, and how the families still go to the cemeteries and do special thing with their ashes. They wear necklace and rings and have ashes that those who had cremated their babies somewhere near them. So it's always, there. So as much as the CPSC study had an impact on them to kind of help them better, understand what happened to them, it's had long-term devastating impacts. And one unfortunate example of one of our families is her twin, her name is Casey, and she had twins, Jameson and Dorothy, and Jameson died when he was an infant in the rock and play, and his dad found him, and a few years later the dad committed suicide. So you have this woman, and in the meantime they had another little boy, and you have this mom who's now raising a 5-year-old, because Dorothy's now 5, and a little 2 or 3-year-old on her own, and losing the death, not only still dealing with the death of her son, but then his father. So as much as this has given them a voice and given them a platform, and it doesn't heal any of the wounds that they've suffered, that they will continue to suffer.
It's amazing what a ripple effect just Fisher-Price and Mattel's actions have had on these families' lives. So would you suggest that attorneys acquire rock and play cases now?
There are if there are infants families that are out there that lost infants in the rock and play, and it is a series of kind of factors that have to be considered, they should seriously look towards representing them as well. We think there's a short window of time that they'll be able to do that because we've got issues, related to a variety of different, legal factors, but it should be something that should be considered because the litigation is now in a variety of different states is moving forward on this.
And have there been any COVID-related setbacks with the litigation, with the court closures?
Yes, but that has happened to every firm, every client, every case that is out there. And, they're never going to get their infants back. And they will always have that loss. So if this prolonged, if COVID and staying safe by staying out of the courts and all of us staying home, protected our lives, that's really what the core of this whole thing is of this, what we're doing at Calcaterra Pollack and what, other families are doing, other law firms are doing. We're trying to protect lives. So if shutting down due to COVID or the court system slowing down, that kind of goes to the genesis of what we're trying to do going forward.
And if we could shift gears a little bit and just talk about your new firm, which you opened in the midst of the pandemic. I know Calcaterra Pollack is a 100% female-owned firm. Is there any other aspects of the firm that make it unique?
Well, there are four. One is the makeup of our team. And then there is our pre-law diversity pipeline program. Then there is a wellness program. And of course, the fact that we launched the firm in the midst of a pandemic. But I'll just focus on the first two. A super majority of our team members are professionals of color and or openly LGBTQ and or DACA recipients and or women. That is the makeup of our firm. And we truly believe that you need to be fostering diversity in your workplace and having people feel comfortable about who they are, because somebody should not be limiting what their self-worth is or what their contribution is, or just being themselves and who their identities are based upon a job. It's something that, like, who they are. So we wanted to make sure that we have an environment that encourages people to be comfortable, in who they are and in their identities, especially people coming from different backgrounds, because those of us who may have like different backgrounds, whether it's economically or socially disadvantaged or being of color or different sexuality or even DACA recipients, we all had to learn how to be advocates for ourselves at a very young age, and we're passionate advocates. So if you bring on a team of people who've always had to advocate for themselves, they then know how to take that energy and channel it to their cases and their clients and provide better representation and do it with such commitment and passion that you may not normally get from somebody who hasn't had unique experiences and hasn't really understood the importance of having effective advocacy. So that is one of the things that we find very unique about us as far as our level of diversity. The other thing that I had mentioned is our pre-law diversity pipeline program, which I did start 4 years ago, but I carried it over to this firm, is that, I've been working with public universities and colleges here in New York and to create this program. And the reason why is because most first-generation college students, a majority of first-generation college students go to public universities. So they may be brilliant, they may be hardworking, have a great discipline, have a great work ethic, but they just don't have the economics readily available to them for them to go to a private institution or Ivy League institution. So I've been working with these colleges to try to identify students that may be interested in the law, that are diverse, and I've been bringing them on, every summer for the past few years. And one of the unique things that we do for this internship is, one, the rule is I manage. So I want to make sure that they're not making copies or, doing errands that they shouldn't be doing, that they're exposed to not only the substance of law, but the ethics of law, but also the business of law. Because when you want to talk about promoting diversity, it's not only giving people who are diverse experiences or hiring them, it's making sure that they've got long-term staying power. Because you want them to be our next leaders. You want them to get to a law firm and then rise up in the ranks to leadership positions. And the way that happens is you have to teach them the business of law, how to get a client, what the business of law is with the substance of law. So that's something else that I feel is very unique, is not only the pre-law diversity program that we have, and that we do get our dreamers from there. We have our paralegal who was a dreamer in that, who is a dreamer and was in the intern program, is now working for us. And some of our other interns are dreamers as well. And so you get these incredibly unique students that you can continue to mentor throughout their their entire legal practice.
That's great. Can you describe the transition from your prior firm to your current firm in the midst of the pandemic? It's amazing.
It was educational. It definitely was educational. I mean, the objective of launching a firm and, leaving my prior firm, where 7 of 8 of us at the existing firm now worked at one time together at the prior firm, was to make sure that our clients had continued representation. So, regardless of a pandemic, and if we're leaving, we still have clients and cases that need to be represented. So we didn't have any choice but to succeed. I mean, if we already told clients, we're leaving, if you want to come with us, come with us, we had to put this together, even though there was a pandemic, because they still needed representation. So so we literally had to work through the pandemic. And that was actually something that was a blessing, because we were so occupied in building this firm and, the back office operation aspect of it, which was very difficult because you need the Secretary of State involved, you need to, incorporate documents and open bank accounts. So we had to navigate all that in the midst of COVID, while also putting together a team who now was going to work together all on Zoom. And so that goes back to our part of our objective about wellness. And my partner, Janine Pollack, is our Chief Wellness Officer, actually. And because she, and we all do believe how important it is to address mental health on a daily basis at our firm, and whether it's, on the weekend or at nighttime or during the day, and to set up barriers for people, because mental health has been an issue within the legal industry for a long time. The ABA last year came out with guidelines as far as how to address mental health, and through a wellness program. And so the wellness program is as important to us as diversity is, because they go hand in hand, because it really has to do with mindfulness and just having people feel comfortable in the workplace, regardless of what their decisions are. I mean, regardless of what they're going through. And so having what we made a commitment to do from the very beginning is that we're going to have morning Zoom calls every single day. Everyone was going to be on the phone call on that Zoom. And if you didn't feel like going on, like on the video, you didn't have to do it. But we wouldn't start out with like, what did you do last night? What work did you do? I mean, what work did you do? What work are you going to do today? We always start out by, how are you doing? Mm-hmm. How was your weekend? We would ask about their family. We would ask about, their partners or things along that line. And then once we get that settled, because we're not in the same office and we couldn't go from place to place to place and kind of check in, it was important for us to do that. And so launching in the midst of the pandemic actually allowed us to focus on not only our clients' representation, but gave us better reflection on what's important in life and who we want to be. And those principles that we fine-tuned during the pandemic is something that we're going to be carrying through with our firm going forward.
Nice. Your firm has really created this environment of inclusivity and like diversity and wellness. What would your advice be to firms large or small about creating like a similar atmosphere?
It doesn't cost you anything to build and continue to implement and embrace this type of atmosphere, the atmosphere for wellness and diversity and inclusion, but it will cost you a lot if you don't do it. So it doesn't matter what the size of your firm is. If you're a big law firm or if you're a boutique law firm, the diversity program that we do with the college universities the public colleges, universities, where, we pay our team minimum wage in the summertime. That's not a lot of money. There are a lot of colleges out there that would easily partner with you on it. And they provide, and just having them around, it's great energy to always have young people around you. And also the work product they do is really impressive. And as far as wellness, again, that doesn't cost us anything. That takes a few people reading the ABA guidelines and figuring out how best to implement them and to make sure that you're embracing everyone's experience at your firm, and it's a place for them not to be limited, but it's a place for their, again, for their self-worth and their individual identities to be embraced. And it comes at, it doesn't cost you anything to do it, but it comes at a large cost if you don't.
Regina, thank you so much for taking the time to speak with us today.
Liz, thank you so much for asking me on behalf of Calcaterra Pollack to be a part of this. I really appreciate it, and looking forward to see you in person soon.
Great.